So I'm going to go ahead and get started. For all of those who are on the line, good afternoon, and thank you so much for giving up a little bit of your afternoon today to listen in to this compliance webinar. My name is Lisa Carlson, and for those of you who I haven't had the pleasure of working with yet, I am a healthcare attorney in Holland & Hart's Boise office. And this webinar is part of our series of healthcare compliance offerings. And today I'm going to be covering the non-discrimination statutes that are applicable to healthcare providers, including the obligations that healthcare providers have with respect to individuals with limited English proficiency and disability, and also how COVID-19 has impacted healthcare provider obligations. So first, a few housekeeping items. This webinar is being recorded, so if you need to drop off or want to refer back to anything we cover, a link will be available to the recording either on the Holland & Hart website or the Healthcare Law blog within the next several days. And we've also made these slides available for you to download. And second, if you have any questions as we're going through, feel free to use the chat or the Q&A feature in WebEx to ask those questions. Also, my contact information is up here on the screen. Wanted to give that to you up front. So if you have any questions, you can also reach out to me directly by email or phone. I'm happy to chat with you more. But we do have a lot to cover today. So if we run out of time, I promise I will respond to you by email. Famous last words. And next, of course, is the legal disclaimer. This webinar is for educational purposes only and does not constitute legal advice. So if you do have further questions, do reach out to your legal counsel for specific advice about how activities may be relevant, or how the law may be relevant to your specific activities or practice. Okay, so today, the overview. I'm going to cover obligations that healthcare providers have with respect to non-discrimination statutes and how those statutes protect individuals both with limited English proficiency and individuals with disabilities. I'll also cover healthcare provider obligations related to service animals, one of my favorite topics. And finally, I'll briefly discuss how COVID-19 can impact providers' compliance with these non-discrimination obligations. So jumping right in. First and foremost, the overarching non-discrimination statute applicable to healthcare providers is Section 1557 of the Patient Protection and Affordable Care Act. So this civil rights provision prohibits discrimination on the basis of 6 protected classes, as I've underlined in the statutory language. These include race, color, national origin, sex, age, and disability. Under the statutory language, this section applies to any health program or activity which is receiving federal financial assistance. And we will go into some of the details here in just a bit. So, as I mentioned, Section 1557 is the overarching non-discrimination statute, but that statute is actually intended to work in conjunction with existing civil rights statutes that protect individuals from discrimination. So examples of those are listed here on the slide. They include Title VI of the Civil Rights Act of 1964, which prohibits discrimination on the basis of race, color, national origin. Title IX of the Education Amendments of 1972, prohibiting discrimination on the basis of sex. Got the Age Discrimination Act of 1975, of course, prohibiting age discrimination. Got Section 504 of the Rehabilitation Act of 1973, prohibiting discrimination on the basis of disability, and the American with Disabilities Act, or the ADA of 1990, particularly Titles I and II, which prohibit discrimination on the basis of disability. And then finally, last but not least, you have to remember state non-discrimination statutes that may be applicable depending on where you're located. So for those of you tuning in from Idaho, we have the Human Rights Act. So just something to be mindful of as you're evaluating your compliance. Don't forget state law obligations. So first I want to spend a little bit of time going over the current status of the ACA, not the whole shebang legal challenge that's going on, but just specific to Section 1557. So obviously the ACA is still being challenged on the constitutionality of the entire statute. But there are legal challenges that have been going on sort of behind the scenes with respect to Section 1557 as it relates to discrimination. So in 2016, the Department of Health and Human Services first issued their final rule implementing Section 1557. And in those regulations, HHS defined discrimination on the basis of sex. They just define that term, on the basis of sex, to include gender identity and termination of pregnancy, with gender identity defined as one's internal sense of gender, which may be male, female, neither, or a combination of male and female. Well, this interpretation by HHS prompted legal challenges that contested the authority of HHS to essentially redefine what it means to discriminate on the basis of sex. And the federal court that decided this case ultimately held that the provisions were contrary to existing federal law, and HHS could not enforce the provisions on gender identity or termination of pregnancy. These legal challenges then ultimately led to HHS promulgating revised rules, which it then issued in June of 2020, effective, I believe, August 18th, 2020. So these are relatively new rules, sort of all happening in the wake of COVID, so didn't really get a whole heck of a lot of headline press, but nonetheless, HHS did issue new rules. And with these new rules, they not only changed the contested definition of discrimination on the basis of sex, but they also took the opportunity to remove several other requirements that imposed unnecessary regulatory burdens on covered entities. So some of the more notable changes I've listed here on the slide, and that includes a revision to which entities and healthcare activities are subject to 1557. The new rules establish that the ACA applies to entities primarily engaged in the business of providing healthcare and that receive federal financial assistance from HHS. So I will talk about that on actually the next slide. Second, though, the new rules also eliminate the protections based on gender identity and sex stereotyping. So ultimately, the agency resorted back to the definition of sex based upon biological gender. And finally, one great change is the agency's elimination of the notice and tagline requirements, which was quite onerous and confusing. So that is probably good news. So as I mentioned earlier, there's legal challenges. There's still legal challenges. Now they're challenging the revision, the newly revised rules, with at least one federal district court in the Eastern District of New York having issued an injunction on the repeal of the 2016 definition of sex. So there's definitely going to be more to come on this issue as to whether these new rules are going to stand. And so we'll just have to stay tuned. So the non-discrimination laws, what does this mean for healthcare providers? And I mentioned who does the ACA apply to generally? So essentially, non-discrimination laws will apply to entities principally engaged in providing healthcare that receive financial assistance from HHS. So you're talking physicians, hospitals, nursing facilities, clinics, medical practices. If you get federal funding, and you provide healthcare, the non-discrimination laws will apply. Entities that are not principally engaged in the business of providing healthcare will apply to the extent that that particular activity it performs receives federal financial assistance. And to comply with the ACA, entities must still submit an assurance of compliance with 1557. That was a requirement under the 2016 rules, and it remains a requirement. However, as I mentioned, the 2020 rule repeals the requirements for covered entities to have to perform a lot of more administrative tasks that were burdensome, as HHS puts it. For example, covered entities are no longer required to appoint a compliance coordinator or have written grievance procedures. The new rules also repeal the requirement for covered entities to post notices of non-discrimination or to include taglines and statements of non-discrimination on certain written materials. So that's great news, I think, for many healthcare providers. The requirements of also, the ones that have remained the same include the requirement to provide meaningful access to persons with limited English proficiency by providing language assistance. Generally, that means through the use of interpreters and translation services. The requirement stands to provide effective communication to individuals with disabilities through the use of auxiliary aids. Healthcare providers must make newly constructed or altered facilities accessible to individuals with disabilities, and they must make information and communication technology accessible to individuals with disabilities. Now, I'm not going to cover in detail these last two requirements, but just wanted to make sure to call attention to them as being within the scope of the standing requirements under 1557. Okay, so for those that don't comply, there are numerous penalties available to choose from. Entities can be investigated by the Office of Civil Rights, prosecuted by the Department of Justice, sued through civil lawsuits by an aggrieved individual, and finally, entities can lose their federal financial assistance and maybe even be subject to termination of their Medicare or Medicaid provider agreements. So compliance with non-discrimination is no small matter and has significant penalties for non-compliance. So now I'm going to go into more detail on the specific obligations with respect to providing meaningful access to those with limited English proficiency. So a healthcare provider must take reasonable steps to ensure that individuals have meaningful access to the programs and services that are offered by the healthcare provider. And this generally means providing qualified interpreters and translations of key documents. Ultimately, language assistance services must be provided free of charge. They must be accurate and timely, and they must protect the privacy and independence of the individual with limited English proficiency. And as I mentioned on the last slide, the healthcare provider is expected to take reasonable steps to ensure that the individual has meaningful access. But what is reasonable? Reasonable is based upon the healthcare entity's balance of 4 factors. So first, they're going to look at the number or proportion of limited English proficient individuals eligible to be served or likely to be encountered in the service population of that provider. Second, the frequency with which limited English proficiency individuals come into contact with the entity's health program, activity, or service. So how often are they actually using the service? Third, the nature and importance of the entity's health program, activity, or service. So how critical are the services that you're providing? And then lastly, the resources available to the entity and the cost involved in providing the resources. So what is reasonable for a healthcare provider with multiple locations may vary based upon the geographic area and the patient population that it is serving. Specific to the obligation to provide interpreters, a healthcare provider must offer a qualified interpreter if doing so is a reasonable step to providing meaningful access. And a qualified interpreter has specific requirements that must be met. Not just any interpreter must be qualified. So the individual must adhere to generally accepted ethical principles, including client confidentiality. They must be proficient in speaking and understanding both English and the language that is spoken by the patient. And they must be able to interpret effectively, accurately, and impartially using necessary specialized vocabulary. And that's particularly important when it comes to the use of medical terminology and any specialized training to be able to communicate complex terms effectively. So, and interpreters can provide these services either in person or using remote audio interpreting. However, remote audio interpreting must satisfy certain standards. These standards generally require use of an appropriate connection that's going to allow a clear, audible transmission of voices, no lagging, and staff that are trained to set up and operate the technology. So pretty common sense. It's got to work, and it's got to work well in order for the patient to be able to understand the communications. Finally, some general takeaways for using interpreters. A list of do not do. Do not refuse to provide care due to cost, and similarly, don't charge for an interpreter. You also cannot require an individual to provide their own interpreter or rely on an adult that's accompanying the individual. There's some exceptions to that. That would be in a case of an emergency where there's an imminent threat and there's no qualified interpreters immediately available, or if the individual requests that their accompanying adult interpret for them, that adult agrees, and it's reasonable to rely on the adult in that particular circumstance. So again, think back to, are there going to be really complex diagnoses or medical conditions being discussed, and is this something where you need a more robust understanding of medical concepts and medical terminology? Also, do not rely on a minor, except again in an emergency and there's nobody else that's qualified immediately available. It's never appropriate to rely on a minor, even if the individual requests that you use their 16-year-old that's right there. Don't do it. And don't rely on bilingual staff to interpret unless that staff member is qualified and designated to provide interpreting as part of their job duties. Okay. So moving on to translations. Healthcare providers must use qualified translators to translate vital documents, both in paper and electronic form. And a qualified translator is similar to a qualified interpreter in that they must adhere to generally accepted ethical principles. They must demonstrate proficiency, this time in writing, English, and the language spoken, or I guess the language that they're translating the document into. And they must be able to translate effectively, accurately, and impartially using necessary specialized vocabulary. It's important to note that an interpreter won't necessarily qualify as a translator and vice versa. They do rely on somewhat different skill sets, so you have to qualify as both in order to perform both services. And for all of you Google Translate fans, don't rely on automatic translation technologies. Just another one of those. Just don't do it. Now, the obligation to translate only applies to vital documents under Title VI. So the question then is, well, what is a vital document? Well, a vital document is one that generally affects a patient's access to termination in or termination or exclusion from a program, services, or benefits. So essentially, the translation of the document is going to be vital to service, and there's going to be consequences if the translation is not accurate and timely. I've listed some examples here of vital documents and non-vital documents. So some examples of a vital document will include applications, consent forms, complaint forms, notice of rights, other types of intake forms, eligibility, like financial eligibility criteria. Non-vital documents, you may have a large document like an enrollment handbook. in a large document where it may not be feasible to translate the entire thing, if there are portions that may be deemed vital, you can certainly and would certainly be expected to translate those portions that would be considered vital. Now, Title VI does not require translation of every vital document into every single language. So an entity may be able to rely on a safe harbor in order to demonstrate that they've complied with the requirement to provide written translations. Under the safe harbor, essentially an entity that provides written translations of vital documents for each LEP language group that constitutes either 5% of its service population or 1,000 people, whichever is less, will constitute strong evidence that they've complied with the written translation obligations. Alternatively, an entity can offer oral translation of vital documents if there are fewer than 50 people in a population that reaches that 5% threshold. So gotta do some math there to figure out if you can fit into the to decide if you can fit into that safe harbor and what your LEP population groups are. So that wraps up obligations with respect to individuals with limited English proficiency. So moving on to healthcare providers' obligations with respect to individuals with disabilities. So healthcare providers may not discriminate against individuals with a disability or regarded as having a disability. And a disability is considered any physical or mental impairment that substantially limits one or more major life activities. This prohibition includes discriminating both against patients and also their companions with disabilities. Now, I've put that in red on this slide because it's really important and one that healthcare providers often overlook. There is an obligation to provide services to a companion, and I'll give you an example. So patient comes in, patient is a minor, parent maybe has a disability. Obviously, the care is being provided to the patient, but in that situation, it's vital that the parent have the necessary information in order to be able to make treatment decisions for the minor. So the healthcare provider would be obligated to provide assistance to the companion of that minor patient. But it also comes into play where the patient, maybe the patient has a spouse that has a disability. Again, the healthcare provider does have an obligation to provide effective communication to the companion of patients. So the obligation is to take appropriate steps to ensure that communications are as effective as communication with individuals without disabilities. And this generally means that a healthcare provider will need to provide auxiliary aids or services. So on this slide, I've provided some examples of auxiliary aids that may be appropriate given a particular patient situation. I won't read through all of these, but I've broken down the options depending on whether the individual has a hearing or a visual impairment. And some options are interpreters, written materials, assistive listening devices for individuals that have hearing impairments, or qualified readers, audio recordings, braille materials for patients with a visual impairment. With all of those options, the question then is, which one do you pick? Well, under the ADA, the appropriateness of the auxiliary aid type will depend on several factors, which I've underlined here. So the method of communication generally used by the individual, the nature, length, and complexity of the communication, and the context in which the communication is taking place. And while a provider should always consult with an individual to determine their preference, the ultimate decision is left up to the provider to make, as long as effective communication is achieved. So the goal and the standard by which the effectiveness of the the auxiliary aid choice will be gauged is how effective was the communication to that individual. Okay, so again, takeaways, the do nots. Do not refuse to provide care due to cost or charge for the services. Do not rely on adults accompanying the individual or require them to provide their own interpreter unless it's an emergency and there's no one that's qualified that's immediately available. And again, if they request an accompanying adult act as their interpreter, the other adult must agree and reliance must be appropriate under the circumstances. And do not rely on a minor. Okay, so why does it matter? I think this is sort of stating the obvious for each of you, but obviously providing meaningful access to limited English proficiency patients or effective communication to individuals with disabilities is that communication is an essential component of proper care. Without appropriate communication, healthcare providers can be liable for failing to obtain informed consent from the patient. And in those situations, a provider can actually be liable for any resulting injuries. Additionally, providers could be responsible for violations of professional licensure responsibilities, ethical standards, and the entity itself could be found in violation of its own accreditation standards. So those are some of the whys. I'm sure there's others. But moving on to service animals. So from my slide here, you can see one of the reasons that service animals is one of my favorite topics is because of the antics that some patients try when it comes to passing an animal off as a service animal when they may not be any type of, may not even be a companion animal, like I don't know, a squirrel or a peacock, but anyway, as you'll see though, dog and horses are the only two that are recognized under the ADA as service animals. Under the ADA, a service animal is defined narrowly as a dog that is trained to work or perform tasks for people with disabilities. And the obligation is that healthcare providers generally must allow service dogs to accompany a person with a disability in all areas where members of the public are allowed. The healthcare provider may be able to limit a dog's access if the dog is out of control and the handler doesn't take effective action to control it, if the dog is not housebroken, or if the dog poses a risk to the health or safety of staff, other patients, or operations. Healthcare providers can require the dog to be on a leash unless it would interfere with the service that that dog is providing. And if it's not on a leash, staff are, if it's not on a leash or a tether, the dog actually must be under the handler's control, whether it's voice or hand control. And staff are not required to provide care for or supervision of a service animal. The individual or handler provided by the individual are expected to be responsible for the animal at all times. And with respect to inquiring about a service animal, I think that's probably one of the most commonly asked questions. You have a patient that comes in, they've got a dog, let's hope it's a dog. Doesn't look like it's performing any type of task or providing really anything of value other than, you know, it's cute and fluffy and they want it to be with them. Well, a healthcare provider is really limited, unfortunately, in the questions that they can ask the individual. So generally, a healthcare provider can ask whether the dog is required because of a disability and what work or task the dog is trained to perform. Can't ask about the person's disability. You can't require medical documentation of the disability. You can't require any special ID cards or training documentation for the dog, or even ask the dog to perform its tasks or its tricks or do its work. And another common misconception is that dogs are required to wear a particular type of identifying vest, and that is not actually true. Although many of them do wear service vests, they are not required to do so. Okay, also I did mention horses, so I'll go back. Horses are not defined as a service animal. However, they are recognized as the same basic rules will apply to miniature horses as they apply to dogs. So it does apply equally to miniature horses, although I think that's probably a less common situation for most healthcare providers to encounter. Okay, so moving on to our last topic, COVID-19 and considerations for providing services to individuals with limited English proficiency and disabilities. So first, it's critical to remember that civil rights protections apply even during emergency situations. So early on in the public health emergency, agencies began issuing guidance reminding healthcare providers of their obligations to continue providing meaningful access and effective communication to individuals with limited English proficiency and disabilities. And this guidance remains in full effect. And just recently, actually, the Office of Civil Rights settled 3 discrimination complaints against a hospital for violations that arose from the hospital's infection control and prevention policies and procedures. And the takeaway there is that that second bullet point, which is beware temporary visitor restrictions. So in this case, individuals with disabilities had varying support needs and were in need of a support person, and the OCR then said individuals with disabilities may need that support person in order to ensure that they have equal access to health care, even during COVID-19 and even despite infection control and prevention policies. So the issue there is to make that accommodation in order to ensure that a person that needs a support person, a patient that needs a support person, has that access. And this can include both inpatient and outpatient situations. Another common guidance topic that the OCR has focused on is the disproportionate impact that COVID-19 is having on varying patient populations. So healthcare providers are being reminded to be mindful of stigmas and stereotypes that may influence the provision of care and treatment decisions during these times. And then finally, a big one is discriminatory crisis standards of care. Particularly arising out of discrimination against individuals with disabilities and on the basis of age. Several states have actually been in the spotlight for implementing crisis standards of care that were deemed to be discriminatory in nature. And so to avoid any such allegations, you really have to be mindful of stereotypes, assessments of quality of life when directing appropriate care, and to make sure that any evaluation as to whether someone is a candidate for a particular treatment should be made based on individualized assessments of the patient and based on objective medical evidence. And of course, those determinations sufficiently documented in the patient's medical record. So that is really all that there is with respect to the COVID-19 considerations at this time. I've put together some additional resources for you that are helpful as you evaluate whether your own practices are compliant with the various non-discrimination statutes. That first one is the most recent ACA fact sheet that talks about some of the changes that were promulgated just recently in June. So the revising of the 2016 initial regulations. And of course the ADA website and the HHS website specific to civil rights for individuals. They have some helpful guidance and education and some fact sheets that make for really good staff education as well. So some really great resources out there, plenty of reading material. And with that, I can answer a couple of questions. I see there's a question about what if the patient cannot provide for the dog's care? So that's a great question. As I mentioned, the patient is the one that has the obligation to be able to provide care for the animal. If they cannot provide the care, it's their obligation to have a handler for the dog. If they can't secure a handler, then it is perfectly appropriate to ask the patient to return at a later date without the dog. Or if they are inpatient, to make arrangements for family or friends or someone to come and get the dog. But it certainly is not the responsibility of the healthcare provider to provide, take the dog out and walk it or take it out, clean up its messes. Can a person claim a dog is for comfort or stress relief? So that's going to be dependent upon if this is the general answer is going to be no. There may be limited circumstances where an individual situation may constitute a bona fide disability, but for most part, when people are coming in with their handheld dog and saying, this is my comfort or my emotional support animal, it's not the same as a service animal. And I think that answers another question is emotional support acceptable as an answer to work or tasks the dog has been trained to perform? And again, it's going to be very limited circumstances to disabilities. Somebody's needing emotional support from their animal may not be included, but certainly a factual determination will need to be made in those situations. Finally, can we require that the support person must be able to comply with infection prevention rules? I think that's perfectly appropriate to the extent that you're requiring any of your visitors or patients to comply with those same rules. I don't know if there's guidance on that very issue, but so I'm going to put that with a answer of likely, but certainly I would, there may be, with caveats, there may be circumstances where a support person maybe can't comply, but I'm not familiar with the guidance on that. Some of these are getting really into some nuances, and I'm not sure I can answer them just off the fly on the top of my head. But I will, you mentioned, do the taglines still have to be posted on the 1557 poster notices? And that is one of those, they just totally abandoned the requirements for the taglines and notices. So the answer to that is no, there's no longer a requirement for those notices to be posted. With respect to qualified interpreters and translators, for those of you who are asking, I'll send out some additional FAQs. It's a little bit too much to go over with respect to how you can go about qualifying someone in order to be able to provide those services. So I will provide answers to those questions offline to those of you who have asked here in this webinar. Otherwise, I'm not seeing any other questions right now that I haven't already answered. But again, I'm happy to answer more questions. You're welcome to email or call. Access to the slides will be available on the Holland & Hart website. For those of you, I believe they also will be emailed out after the presentation. And just by commenting here, also, I now know that you would like a copy of the slides. So if you have any additional questions, I will gladly take those via email, and we'll follow up with each of you offline. Otherwise, I hope you all have a wonderful rest of your afternoon, and take care.